were discussing about um, the initial, you know, the conception of natural law. So I'll just explain you briefly where we were and where we are heading towards and why this change. Am I audible?
Yes, ma'am.
So we had discussed Greeks and Romans philosophy of law, and thereafter I took you to the impact of to the medieval ages. Early medieval ages were called as dark ages. So therein the impact of religion was, the preponderance was given to the religion, meaning thereby that the state was set to function only to uphold the principles of Christianity. So, whatever action the state had taken, whatever rules the state had promulgated, if they were in consonance with the principles of Christianity, they were considered to be valid, otherwise not. So, religion had a very major role to play, and with the passage of time, the philosophers started segregating the religion from law. Now, this was pre-Renaissance and post-Renaissance, pre-Renaissance and thereafter, at the end of 18th century and in the beginning of 19th century, uh, we saw the birth of analytical positivism, analytical school, analytical positivism. Uh, yes, analytical imperative or positive school in your terms and approach in my terms. So, since this is the part of the syllabus, we'll cover this first and thereafter we'll come back to natural law where whenever the schedule will permit. Wait. Okay. So, understand the points. Before starting with this, make this short point in your notebook. From exam point of view, both internal, external, and this your competitive exams, you will have to understand. You'll have to make note of works of jurist. Secondly, you will have to make note of the philosophy, meaning of law given by a particular jurist. Third, you will be writing where whenever we will discuss criticism, whenever and wherever we will discuss criticism, you will write a critical note. And thereafter, wherever we'll discuss the Indian perspective, you will write the same. So we will go by the schools oblique approaches plus jurist. For every jurist, you have to prepare all these 4 points. ठीक है, इतना तो करना ही है. Plus beyond this, in case if somebody wants to read additional points, additional philosophies, additional concepts, elite concepts, additional concepts associated with this, anybody wants ebook of a particular jurist, that person can always write an email to me and take it. Now let's start with Germy Bentham, analytical, thereafter positive, oblique, imperative. Now, when we use the term imperative, it means a mandate. So, analytical positivism, in analytical positivism, why these terms have been used, why these approaches, these three terms have been used when we define analytical, a school or approach. Imperative means mandate. So, something which emanates from the mandate of the sovereign. Something which emanates, the origin can be traced to the will of sovereign. Why positive? Positive means they are concerned with what the law is. They are not concerned with what the law ought to be. Yes. And thereafter, analytical means analysis of the principle, analysis of the existing principles. Thereafter, let's just come to germy bentham first. Let me explain the definition of the law. इसमें philosophy में ना बेटे there will be 5 to 6 points in germy bentham. I'll just explain you all the points. Firstly, let's meant by law in the term of what is meant by law in the terms of germy bentham. This is the definition of law. It is, he says that law is an assemblage. Law is an assemblage of signs. Assemblage means collection. Assemblage means collection. Of signs means your will. Signs means conveying. बोलते ना sign language, you do this. I have directed that you all should submit your PSJ topics by 5th of Feb. What is this? This is a direction. This is a sign. Sign language. During our classes, when I used to say that don't talk, it means what? I am trying to convey my will. Declarative or volition. Declarative or volition. Volition means will. Assemblage, collection of signs, what I want to express through my through declaration of will. ठीक है ना, साइंस का लिख सकते हो expression. Mode, how I will convey, what I will convey, what I will declare is declarative of volition. Thereafter conceived or adopted. Either that is my will, I have conceived it, I have introduced it, or adopted, I have adopted will of my predecessor. The rule was already there, now I have merely adopted that rule. By the sovereign. Who is a sovereign? He is a person or a body of persons, he says, who is habitual of being obeyed by the bulk of the community. And his will is given preference. His will is given preference over anybody else's will. His will is given preponderance. सबसे ऊपर बोलते ना सर्वश्रेष्ठ, सर्वश्रेष्ठ, सबसे ऊपर. बॉस ने बोला ऐसा करना है, that's that. Sovereign in a state, he is habitual of being obeyed. Who is a sovereign? Who is habitual of being obeyed by the bulk of the community. And his directions, his volition is given preponderance, it is given preference in the state concerning the conduct. Now, what is this will? What is this volition all about? It is basically, it concerns, it regulates the conduct to which to be observed in certain case. Certain case means a certain situation by certain person or class of persons. So this is basically representing bulk of community. Community, yes, community is a fictitious body, he says. Community is a fictitious body. We will discuss the definition of community given by germy bentham in a short while. Who is in the case? Who in the case question are supposed to be subjects of his power. So what is law according to germy bentham? It is assemblage. Assemblage means collection of signs, of directions, of expressions. Expressions of what? Expressions of will. Expressions of will. Whose will? Sovereign's will. Who is a sovereign? Who is habitual of being obeyed by the bulk of given community, and they are under mountain duty to give preference to his will. And now whether these rules, whether these directions, whether this will has been conceived, has been introduced by the sovereign, or it has been adopted by it. Adopted by it means already exist करते थे, नया कुछ नहीं लेकर आया. Already exist करते थे, उसने खाली adopt ही करा. He has only followed it. That's it. Now, what is this will all about? It is, the object of the same is to regulate the conduct of its subject. First point you will write, in your germy bentham's notes is limits of jurisprudence defined. Limits of jurisprudence defined is this is your this is his first work, limits of jurisprudence defined. Thereafter second work वाले column में you write limits of jurisprudence defined. Second में you will write definition of law. So this is a definition of law. Elements, whatever ingredients we have studied, you will be writing those and you will be explaining the same in the set format. Moving ahead, thereafter he says that when we understand the definition of law, it is to be understood from 8 aspects, from the point of view of 8 aspects. Now, what are these? These are source. Now, what is a source of law? 8 aspects of law. Source of law is will of sovereign. What is the quality of the subjects? Quality of the subjects. Now, for subjects means law banaya. 6th L के लिए law banaya, rule banaya. The extent and the application will come, we'll discuss here. But herein, for whom the law has been made, from where, ठीक है, where and whom the law has been made. Now in this he divides laws into 2 categories. One is laws by principem and laws of populum. Meaning thereby, principem are the laws which are transcendental. Transcendental in nature, meaning thereby that the set of laws that govern the conduct of the sovereign himself or the authorities which are associated in implementation, which are associated with the sovereign. Principem, higher order law. We can't correlate with the Constitution of India because I have never ever read it. Drawing analogy, that analogy has never been drawn with laws of principem and with the Constitution law. But for your basic understanding, if we correlate it with the laws of principem, transcendental law, then you can understand it. For example, what is the role of the Constitution of India? It envisages, it creates, it delineates, it creates 3 organs of the government. It delineates the powers of the 3 organs of the government. It imposes limitations. It imposes restraint on the 3 organs of the government. It ensures that all the 3 organs of the government function within the scope of their respective powers, which have been given by the Constitution, and they do not usurp. And in case if they usurp, if they exceed the power or they exceed their respective powers, then in that case the consequences have already also been mentioned. Yes, that regulate the conduct of the sovereign. Thereafter, populum means ordinary laws. Principem means transcendental laws. Populum means ordinary laws, meaning thereby ordinary laws that regulate the conduct of human beings, that regulate the conduct of subjects. All the ordinary laws, the procedural aspect, if you say, you take example of substantive laws, civil, your civil rights, your IPC, protection of your body, reputation, property. So all the sides, I mean substantive laws, on whether on civil side, whether on criminal side, whether on commercial side. What do? They regulate the conduct. They regulate our conduct, individuals' conduct. One. Thereafter, they regulate the conduct between the transaction between individuals and individuals. Individual and individual. They regulate the conduct of group of individuals. They regulate the conduct of one group of individual vis-a-vis group of individual, the another group of individuals. So they fall under the category of laws of populum. principum and populum. बेटा, are you all there with me? हो क्या?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
I hope OHT is not happening. ऊपर से तो नहीं जा रहा? चलूं आगे? बेटा एनर्जी लगती है, समझ आ रहा है तो ठीक, नहीं आ रहा तो मुझे बताओ, आई विल रिपीट. पेस इज फाइन, आ रहा है? ठीक है. Thereafter, objects and extent and aspect. See, when we talk about object, these are circumstances. Circumstances बोलते ना, case, the situation for which the object, the mischief for which the remedy has been, provided in the statute. Why the law has been enacted. ठीक है ना? Why the law has been enacted. Every time, whenever we read a statute, we always refer to the long title or the preamble of the statute. We also refer to the statement of reasons and objects, that why the law has been enacted, what was the need for the law. And in cases where amendment is passed, then also we delve into the reason why the amendment has been passed. And thereafter we start studying the lacunas which are there in the amendments, isn't it? Object, बोलते ना, where, कहाँ से आया, किसके लिए बना, और क्या क्यों बनाया गया, है ना? Why? So you can associate it with why. You will not find these words in your notes, मतलब where, whom, why. This is only for your understanding, because this is how I understand and this is how I want you all to understand. All right, you can you are free to disagree and you can interpret it in your own terms also. I have no issues. Thereafter, extent. Now, in every section you will in every statute you will find section 1, short title and extent of operation. बोलते ना, किस पर लागू होगा लो, क्या एक्सटेंट है इसका, ठीक? If you are standing here, then to what extent, to whom, on whom, you correlated it with territorial application of the laws. You correlate it with the classification of the people also. For example, the Hindu Marriage Act 1955 and all the laws which are there in the Hindu code. Who is a Hindu? On whom the law will be applied. Subjects में भी आएगा, but ये extent and operation में भी इसका part आएगा. And we'll talk about classification of people. Thereafter, aspect. Aspect means aspect means context. Thereafter, force. Force means if you will not do this, force of law, बोलता ना, force of law, dowry prohibition. Why? Force of law is there. There is a law behind it. Why you are not, theft. The reason behind it. All the criminal offences, the reason behind it, they have sanction of law. Why in case of breach of contract you have to pay the damages, because it backs. Now you go back to the law of torts classes. Ubi just ebe remedium. Wherever there is a law, wherever there is a right, has to be a remedy. And in fact, go back to alternative dispute resolution initial classes. Wherever there is a law, there is a right, there has to be a remedy. And what kind of remedy? वो बोलते ना, legal rights, social rights. Contract की initial classes में जाओ. Recognition of social agreement का breach हुआ, then you don't have any liability. Legal agreements का breach हुआ, then only agreements enforceable by law का breach हुआ, then only 73 will be invoked. Having back of law. Thereafter, expressions. Expression means signification. Okay, this I will take up again with the idea of complete law. इसको रुक जाओ. Thereafter, remedial appendages. Remedial appendages means सब्सिडरी लॉज, सब्सिडरी लॉज, इसको समझना बेटा, एग्जाम्पल्स ऐसे ही लिखना. आई विल टेक यू बैक टू दिस शीट and I'll explain you the concept of delegated legislation. Remedial appendages में you write these examples. देखो, Parliament and state legislature. Union legislature and state legislature, they are interested with the powers to make the laws. Now Salmon classifies legislation into two categories. One is supreme legislation and the another is subordinate legislation. Now in India, if we say we can correlate it with the concept of delegated legislation, rule making powers. Now take example of Legal Services Authorities Act. In this, central government, state government, 27, 28, they have been empowered to do what? They have been empowered to make rules and regulations. They have been empowered to make rules and regulations. They have been empowered to make rules and regulations, and who has empowered them to make rules and regulations? The Parliament has empowered them to make new rules and regulations. We have studied NALSA regulations, we have studied Supreme Court regulations, we have studied Lok Adalat, permanent Lok Adalat regulations also. Who has empowered them? From where? What is the source of their power? They see if we talk about three organs of the government, separation of powers or division of powers in our country, not separation of powers. Legislature, executive, judiciary. It is to interpret the law, implement the law, make the law. So the primary function of legislature is to make the law. And thereafter, when it delegates, because it cannot, while enacting the Legal Services Authority Act way back in 1987, it cannot have foreseen the requirement for introduction of permanent Lok Adalats, or for that matter, requirement for e-Lok Adalats. It was not, it's not feasible to perceive all the technicalities, all the situations beforehand. No, it cannot. And wherever technical assistance is also required, ground realities have to be taken into consideration. Then in that case, Parliament, supreme power, Parliament or the state legislature, who has whose primary function is to legislate, it delegates its power to certain authorities to make the rules, to make the laws. Rules, regulations, bylaws, they fall under the category of statutory instruments. DDA ने rules बनाए, for example, bylaws बनाए. ठीक है, म्यूनिसिपल कॉर्पोरेशन दिल्ली के कोई भी किसी भी जो जोन की देख लोगे ना, वहां पर you will find bylaws. What are these? Why they have been made? They have been made to regulate the the actions of the people, to regulate the conduct of the people, they have taken into consideration the technical requirements. All these, what are these now? Why rules? What purpose? And thereafter, next example is again of PIMS rules, pre-institution mediation rules 2018. ठीक, अब ये सारे rules क्यों बनाए गए हैं बच्चे? Because the object of these rules is to further the objective with which the main statute was enacted. वो law बना उसके ऑब्जेक्टिव को फर्दर करने के लिए, उसके ऑब्जेक्टिव को मीट करने के लिए ये रूल्स, ये रेगुलेशंस बनाए गए. ताकि वो चीज इंप्लीमेंट हो जाए, ई लोक अदालत ऑर्गेनाइज हो जाए, लोक अदालत ऑर्गेनाइज हो जाए, कौन ऑर्गेनाइज कराएगा, क्या सैलरी होगी, कितने पावर्स हो, क्या पावर्स होंगे, ठीक है। सब परमानेंट लोक अदालत कैसे, कॉम्पोजिशन क्या होगी, कितने पावर्स हो, क्या पावर्स होंगी मेंबर्स की, राइट। It has all been these form part of remedial appendages. So these are 8 aspects of law. So we have covered one, we have covered meaning of the term law. Thereafter we have covered meaning. First I gave you the definition of the term, I told you about work. Secondly, we have covered definition of the term law, and third we have covered 8 aspects of law. ठीक है बेटा, ये थर्ड पॉइंट हो गया. अब नोट्स में यू हैव टू मेक दिस लाइक दिस. See, I'll be sharing this handout, this definition and this handout with all of you today itself. So what you are required to do is only make pointers, write definition, 5 to 7 points which I am going to discuss. Your answers should revolve around that only. Nothing more than that, nothing less than that is required. For every jurist, separate sheets or separate register as the case may be, you must uh, make such kind of arrangement. ठीक है, बाद में problem नहीं आएगी. Let's move ahead. Further, he classifies jurisprudence into, this is your fourth point, expository, expositorial or expository jurisprudence and sensorial jurisprudence. Expositorial jurisprudence and sensorial jurisprudence ought to be what the law is, ought to be, and what the law is. He says that we are concerned with what the law is. And yes please, देखो बेटा बोर्ड देखो, दिख रहा है ना, एक्सपोजिटोरियल लिखा है मैंने, EXPOSITORIAL. Is the screen visible?
Yes, ma'am.
EX. अब आ रहा है बच्चे? Okay. And sensorial ought to be. Thereafter, for this will be the fourth point, and thereafter fifth point will be principle of utility. इससे क्लैरिटी ज्यादा है राइटिंग में? This is better, or it should be thick? This is better, yes. Okay. Understand this, that readings are divided into 2 categories. One is this first part. You will be preparing this first part. You'll be referring it for your end-term examination. ठीक? And this part, this germy bentham's, whatever additional readings I'll give you, with respect to whatever I'll give you from the books of the jurist, that you will be referring only the marked portion, उससे ज़्यादा नहीं. For principle of utility, you will be referring to this handout, these 2 pages only. ठीक है? And this I have taken from Lloyd's Introduction to Jurisprudence. इसके Lloyd's Introduction to Jurisprudence में at the end of every law approach, ठीक है, they have taken they have mentioned the work of original jurists. So what is meant by principle of utility? Let's understand it. I'll wind up the class by 11 sorry 1:20, and this I will continue. I'm giving you overview of principle of utility today. Tomorrow we will complete and we will start John Austin. First point, nature has placed mankind into under the governance of two sovereign masters, that is pain and pleasure. Pain and pleasure. Nature has placed mankind, all of us, under two sovereign masters. These are pain and pleasure. Meaning thereby, pain and pleasure, they regulate our conduct. They regulate the way we think. They regulate the way we act. They regulate our conduct, meaning thereby they regulate the way we think, the way we act in a given situation. The easiest example, and you correlate it with your common your day-to-day life. Why all of you are working, most of you are working hard for working hard for your exams as well as for your as I'm presuming and assuming that you all are working hard for your in your exams, for your vivas and for your internships. Why? Because you want, what is luring you? What is luring you? You want the best, you want to be recruited by best of the law firms at the end of your uh, of your course. Now what is uh, what are you avoiding? You are avoiding pain by indulging into, by giving your 100%, you are avoiding pain. What is this? What is the pain I'm talking about? In case if you are not able to clear your exams, then in that case, you'll not be able to get through your course. Two things regulate our conduct. या तो हम किसी चीज के डर से करते हैं काम, या फिर हमें कोई चीज का फायदा दिख रहा होता है, then reward lures us to work. Both of them, they are sovereign masters. Both of them, and he says that both of them are sovereign masters. Now, as far as for pleasure, he has enlisted a few examples. For example, reputation, identity, pleasure of reputation, pleasure of identity. On the contrary, pain of animosity, pain of loss of reputation, stability. So what are these all about? It is about our conduct. Thereafter, moving ahead, he says that one, and thereafter it recognizes subjection and assumes it. आगे आ जाओ. Here. By the principle of utility is meant the principle which approves or disapproves every action whatsoever according to the tendency which it appears to have augment or diminish the happiness of the party whose interest in question, or what the same thing in other words is to promote or oppose happiness. Now this action can be, he says, this action can be of an individual or of government, but not only of individual, of private individual, but every measure of government. Four words. Four words. Augment, diminish, This is the last point for today's discussion. We'll wind up this tomorrow. Last point of today's discussion. Two more points are there under Germy Bentham, principle of utility, and thereafter idea of complete law. And we'll wind up tomorrow. Augment and diminish, and thereafter promote and oppose. The yardstick for, according to him, the yardstick of for a valid law is its ability to augment, to increase the, or to promote the happiness, to increase the pleasure of the people at large. And in case if the law diminishes, or diminishes means decreases, or opposes, it opposes to the happiness of the people, it does not provide security to the people. It does not provide, if it does not provide equality to the people, it results into, if the action results into pain, then in that case it is not said to be a good law. So the yardstick according to him, the parameter according to him, is the parameter for valid law according to him is its ability to augment or to promote happiness. And in case if the contrary, if the opposite appears, if the opposite of the same is there, then in that case it is not considered to be, it is not considered to be in consonance with the principle of utility. And principle of utility according to him is the basic essence, basic parameter with which the law has to be in a consonance with, has to corroborate, what it has to incorporate this principle in the law, then only it will be considered to be a valid law. Now tomorrow we will discuss about utility. I'll take up this discussion again. I'm not satisfied with the discussion abhi. 4 points itna yaad rakhna, but this is your 5th point for today's discussion. Augment, promote, diminish, oppose. Tomorrow we will discuss about aims of law and aims of law, Germy Bentham's definition 1. Secondly, we will discuss the meaning of the term utility. Third, we will wind the principle of utilitarianism or utility, and thereafter fourth we will discuss idea of complete law. Complete law. That's it. 20 minutes tomorrow to Germy Bentham, and I'll introduce John Austin. From next week onwards, I'll convert your PhD into regular class. So 5 classes next week. Just your only job is to prepare simultaneously, nothing more than that is required. Arnav Raj and